Good evening, friends. This time, let us know the defenses to the rule of strict liability. So, as advocates, you have to defend your client. So, first of all, you must see whether this case fits into any so-called exception, because we can save him. We can't say that he is not a tort, but you can get exception basing on the general exceptions. Already we know those general exceptions like plaintiff the wrongdoer, or voluntary non-fit injuria, inevitable accident, act of God, necessity, mistake of fact, all these things are there. Now coming to the point of exceptions to the rule of strict liability, normally we'll tell you, you remember 5 exceptions. 5 exceptions will be sufficient. Already 2 we already discussed. Anyway, let's once again tell. Number 1, plaintiff's own default. So when the plaintiff himself committed the default, when he himself committed the act, then he cannot get compensation. There is laxity. There is a laxity on the. There is a default on the part of the plaintiff. In such a case, normally you can't get any damages. So best example is Ponting versus Noakes. P-O-N-T-I-N-G. Ponting versus Noakes, 1849. What happened is Ponting's horse, it has jumped the fence. It has jumped the fence and entered Noakes' garden, where he was actually growing, or he was growing a garden in which in the garden there are certain poisonous trees. So poisonous trees like yew tree, Y-E-W-T-R-E. So this horse has nibbled certain leaves of the yew tree. Nibbling means టకటక కొరికి మామూలుగా తింటా ఉంటాయి కదా చిన్న చిన్న మొక్కల్లాగా. So it has nibbled certain leaves of the tree, and since they are poisonous, after coming, then it has affected the poison and he died. Now he filed a case against Mr. Who is that man? Noakes. But the High Court, the Court of Appeal did not accept, because already it was under the control of the defendant. He has arranged a fencing also around the same, and there is no fault on him. It is your fault to let your horse go to the other side or to stray into others' garden, and if it has not gone into the garden, nothing would happen. So therefore you are at fault. It is only due to your default, no damages. Exception 100% accepted. Right? Second is act of God. Already you know, act of God means forceful nature of the circumstances. You don't expect, like tsunami, flood, glacier, all these things, they are all this thing. So best example is Nichols versus Marshland. Already told you, 1876. So what happened? Marshland, he has constructed artificial lakes, and he has covered the lakes with big boulders, that is boundaries, and all of them are perfectly arranged. But due to the act of God, there were torrential rains, because there were floods, due to which the water from the reservoir, so the reservoir was breached and water came out, and it has washed away 4 bridges belonging to Nichols. Right? So ultimately it was proved to be a case of act of God, accepted, no compensation. Next, consent of the plaintiff. So if you volunteer, already told you, voluntary non-fit injuria, like that, here please remember consent. So if you have given consent to the tortious act, then if it is done, you can't claim the so-called damages. Almost. This case is Karstein versus Taylor, 1871. So Karstein was staying in the underground floor of the defendant, that is Taylor's building. Right? Taylor was in the upstairs and plaintiff was in the down floor. So the water overhead tank, the water from upper side will come to this man and he will use the same. So one day the water has flown from the upside to this portion of our client, that is Karstein, and it has damaged some of his properties. Of course, here it has been clearly stated that there was no fault on the part of the defendant. Taylor did not do any mistake. By the circumstances, so they have gone, the water has come down and some damage was done without negligence, right? Therefore, so here the important point is the water was stored for the benefit of both these people. So you have given consent knowing that if the water comes down, your properties will be damaged. So therefore, since you have given consent, it can be taken as an exception. Right? Next is act of third party. This can be called as act of a stranger also. So no doubt you are doing some act whereas it was obstructed to by some other party whom you do not know, and if it causes any tort or damage to the property of the others, you are not liable. Right? If the harm is caused due to the act of the third party, the defendant will not be liable. Case law, Box versus Job, 1879. So the overflow of the defendant's reservoir was caused by blocking of the drain by certain strangers. So D was not held liable. Okay, we discussed that case also. Last is statutory authority. So governmental authority. So if any act done under the authority of a statute, definitely you can take the good defense. Of course, yesterday I told you the case of state of Rajasthan versus Vidyavati in 1962, wherein I stated that the liability of the state is there if any public officer is found doing some mistake or tort. Here, if such thing is done, if it is done in the discharge of official duty as a statutory authority, best definitely it will be a good defense. Best example is Pagadal Narsimham versus Special Officer Nellore Municipality in 1994, wherein the vehicle was towed from VRC center to some Reddy petrol bunk by the police, with the assistance of police by the municipal authorities, and there was damage to the vehicle of Pagadal Narsimham. But because of the statutory authority, there is no necessity to pay compensation because they are not negligent. They tried their best to take care of the vehicle. But of course, some damage was done. Another case, this is Green versus Chelsea Waterworks Co. Chelsea Waterworks Co. 1894. Right. So Chelsea Waterworks Co. has got a statutory duty to supply water to the entire maybe city of London. I don't know. They are having the duty to supply water, right? And the main pipe was burst, due to which the premises of the plaintiff, that is plaintiff is Mr. Green, were definitely flooded with water. But here they could establish, Chelsea Water Co. could establish that there was no accident, so there was no negligence on their part, and this occurred due to sheer accident by breaking of the pipe, because accidentally it happens, right? So therefore it was held that he was not liable for the he was not liable for paying compensation as the company was doing a statutory duty. So these are the exceptions. Please study well and enrich your legal knowledge. Thank you.